Ever feel like some of the most important rules, the ones that actually protect you every single day, are like hidden in plain sight? Like secret powers you never knew you had. Well, today, we're busting those secrets wide open.
It's true. And what's surprising is how many people, like Marcus in our source material, whose phone got confiscated, they just don't know about fundamental protections, like your right to film police. And
Exactly.
that's just one example we'll unpack today.
Right. We're diving into this stack of insights, revealing these sort of hidden legal protections you probably never learned about.
Yeah.
Think of it like sharing, I don't know, empowering secrets that can immediately make a real difference in your life.
Yeah, if we connect this to the bigger picture, it's really about shifting from maybe feeling a bit vulnerable to being genuinely well-informed. These aren't, political opinions.
Yeah.
They're legal facts. Facts that can shield you, your family, and all sorts of situations, work, healthcare, online, you name it.
Okay, let's jump right into the workplace then, because this one I think is truly shocking for a lot of people. Can my employer actually fire me just for talking about my salary with a coworker?
That's a fantastic question.
Yeah.
And the answer, for the vast majority of private sector employees anyway, is a clear no. It is generally illegal for your employer to fire you for discussing your pay with coworkers.
Wow.
Our source material even highlights someone, Jennifer, who was fired for exactly that, and she had no idea it was illegal.
So why is this such a secret then? I mean, what's the legal backing for this?
Well, it's a key protection under the National Labor Relations Act, the NLRA. It protects something called concerted activity.
Concerted activity.
Yeah, it just means when two or more employees act together for their mutual aid or protection, regarding terms and conditions of employment. And the important thing, it applies whether you're in a union or not.
Oh, okay. So it's not just about discussing wages then. Sounds like it's broader.
It absolutely is broader. Section 7 of the NLRA gives you the right to discuss wages, sure, but also benefits general working conditions with your colleagues.
Even online.
Yes, even talking about pay on social media like Facebook or X, sharing salary info with unions or the media or even just the public, joining coworkers to ask for better pay, circulating petitions about work issues.
What about safety?
Even refusing to work in unsafe conditions as a group, that's protected. And there was a recent NLRB ruling, December 2024, that hammered this home. An employee fired for discussing wages got full reinstatement and back pay.
That's powerful stuff. So, okay, what does this mean for employers? What are they specifically not allowed to do?
Right. They absolutely cannot fire you, threaten you, or discipline you for having these kinds of discussions.
No policies against it either.
No, they can't have policies that prohibit wage discussions. They can't question you coercively about these activities. And definitely no retaliating if you file a complaint with the NLRB. The core insight here really is that your power at work often isn't just you alone. It's your collective voice. These laws exist to kind of level the playing field.
Is there any exception? Like, can I just share anyone's salary info if I find it?
Good question. There's a key distinction. You can always share your own salary information. That's yours.
Great.
The exception is if your job involves accessing company payroll info, then generally you can't just disclose other employee-specific salaries without permission, but that doesn't stop you talking about your own pay.
Cut.
And it's worth noting some states, like Colorado, have even stronger protections, wage transparency acts and things like that.
Okay, let's switch gears. From the workplace to, say, public spaces.
Yeah.
We started with this, but let's dive deeper. The right to film police. You said it's not just a suggestion.
Not at all. It's a fundamental First Amendment right, recognized by federal courts across the country. Oh, yeah. Rulings in 2022, even a recent one in 2025 about live streaming, they've consistently said, yes, you have this right. The core idea, you see, is that recording police in public is a crucial check on government power. It promotes transparency.
So what does that court clarity mean, like, practically? Can an officer just tell me to stop filming?
They can't order you to stop just because they don't like it, as long as you're not actually interfering with what they're doing.
And they can't take my phone.
Not without a warrant. Or delete your recordings. Absolutely not, under any circumstances.
Wow.
There was even a ruling against an officer who tried to block someone's view or shined a flashlight in their camera. The court said that violates the First Amendment because it could chill a person from continuing to film.
That's incredibly important to know.
Yeah.
But I assume you need to be sensible about it, safety-wise.
Absolutely. While you're asserting your right, prioritize safety. Don't interfere. Stay a reasonable distance.
And if they ask you to move?
If an officer asks you to move back for safety reasons, you should comply, but you can keep recording from that new spot. And always try to remain respectful. It usually helps.
What about the audio part?
Ah, yeah. Video in public is broadly protected. Audio can be trickier because states have different laws. Some are one-party consent, only you need to know you're recording. Others are two-party, everyone involved needs to know.
But for police in public.
Generally, recording police performing official duties in public is protected because there's no reasonable expectation of privacy for them in that context.
Okay. Moving from public spaces. Let's talk about something really personal. Healthcare privacy. High P. People think it's just about stopping gossip, right? But it's more?
Oh, much more. What's fascinating here is the level of control HIPAA actually gives you over your own medical information.
Like what specifically?
Well, you have the right to access and get copies of your medical records, usually within 30 days. You can ask for corrections if something's wrong. You have the right to know exactly how your information is being used and shared. You can even ask for limits on certain uses or ask them to communicate with you confidentially, like sending results to a different address.
And they have to give you that privacy notice thing.
Exactly, the Notice of Privacy Practices. And listen, there are important new protections for 2024-2025 regarding reproductive health information.
Oh, yeah.
Yes, providers cannot use or disclose that info for investigations or to impose liability, provided the care was legal where it happened.
That's significant. So who has to follow HIPAA? Is it everyone who knows something about my health?
Not quite. It's primarily healthcare providers, insurance companies, and these things called healthcare clearinghouses, plus their business associates.
So not my boss. Or my fitness app.
Probably not. Most employers, life insurance companies, many health or fitness apps, they don't have to follow HIPAAs unless they're directly linked to those covered entities somehow. The core insight is your health data is yours, and HIPAA aims to give you control.
All right, let's talk about home. Housing rights. Imagine, like, your heater breaks midwinter, landlord ignores you. That happened to Sarah in our sources. You have rights there too, right? Even if the lease is basic.
Yes, this is critical. There's something called the implied warranty of habitability. It's a fundamental right in every residential lease, written or oral.
Implied warranty.
It means landlords must keep the property safe, sanitary, livable. You can't sign this right away. Even if the lease says as is, this warranty still applies.
Why? So what kind of things must a landlord provide under this?
Okay, think basics. Working, plumbing, heat, electrical systems, hot and cold water, adequate heat, especially in winter, secure locks on doors and windows. The place needs to be structurally sound, free from major pest infestations like rats or cockroaches. Working smoke detectors are essential, and they have to comply with local housing codes.
So the basics for living safely.
Exactly. The fundamental idea is that basic human dignity in your home is a non-negotiable legal baseline. It's not dependent on what's written down on paper.
That is huge. So what if the landlord isn't making these essential repairs? What can you actually do?
First step, always. Document. Send a written notice to your landlord. Certified mail is best. Keep copies. Detail the problem clearly.
Okay, written notice first. Then what?
If they don't respond or act, you can report them. Contact your local code enforcement or health department.
Can you fix it yourself?
In many states, yes, especially for emergencies. You might be able to use repair and deduct, fix it, and take the cost out of your rent. But check your state's specific rules on how to do that properly.
What else?
Other options could be rent escrow, where you pay rent to a court instead of the landlord until repairs are done, or seeking a rent reduction. In really bad, unlivable situations, there's something called constructive eviction. Meaning the place is so bad you're basically forced out. The law treats it like you were evicted, potentially relieving you of the lease. But again, these steps vary by state. What's crucial, though, landlords cannot retaliate against you just for asking for your rights.
Okay, let's unpack maybe one of the biggest issues today. Digital privacy. With all the data collection, what rights do you actually have over your personal info?
Right. And what's really empowering here is that even though there isn't one big federal privacy law covering everything, things are changing fast. Over 20 states now have their own consumer data privacy laws as of 2025.
20 states? Like who?
Yeah, places like California, Colorado, Connecticut, Virginia, Texas, Florida, a growing list. And more states are joining them. So even if your state doesn't have one yet, momentum is building, and some federal protections exist too.
So if you live in one of those states, what kind of control does that give you?
Generally, you get some powerful rights over your data. The right to know what personal data companies are collecting about you, the right to access it, get copies.
Can you fix mistakes?
Yes. the right to correct inaccurate information, and, importantly, the right to delete your personal data, although there are exceptions.
What about stopping them from selling it?
That too. You usually get the right to opt out of the sale of your data, opt out of targeted advertising, and sometimes opt out of certain kinds of automated decision-making or profiling.
Wow.
And California is even adding a rule, starting 2026, I think, for a single way to tell data brokers, delete my info, making it easier.
And for everyone else nationwide, are there any protections?
Yes, there are specific federal laws. COPIA protects kids' online privacy under 13. GLBA deals with financial privacy. FCRA covers your credit reports. FERPA is for education records.
And the FTC.
Right, the Federal Trade Commission.
Yeah.
They have broad authority to go after companies for unfair or deceptive practices related to data privacy, even without a specific law covering that exact situation.
Okay, so we've covered a lot of these surprising rights. Knowing them is one thing, but actually using them is another. What's the best practical advice for protecting and asserting these rights?
The absolute number one thing, document everything. Keep really good written records. Save emails, texts, letters. Take photos or videos if it helps show the issue. Always note down dates, times, and who you spoke to. Build that paper trail.
And you mentioned communicating in writing.
Yeah.
Even after a phone call.
Exactly. If you talk to someone, follow up with a quick email summarizing what was said or agreed upon. For really important requests, like that notice to your landlord, use certified mail or an email service with read receipts. Keep copies of everything you send and receive. That documentation is your evidence.
Right. And finally, knowing where to actually get help, because this can feel, well, overwhelming.
It definitely can. But there are places to turn. For workplace rights issues, the National Labor Relations Board, NLRB.gov, is key.
Right.
Housing discrimination. HUD, the Department of Housing and Urban Development, they have a hotline, 1-800-669-9777.
Consumer problems, like scams or data issues.
The FTC is great for that. Reportfraud.ftc.gov. And don't forget your state attorney general's office, they often handle consumer protection. Plus, look into local legal aid societies. They often provide free or low-cost legal help if you qualify.
And act fast, right?
Crucial point, act quickly. Many of these rights have deadlines, called statutes of limitations, for filing complaints or lawsuits. These vary by state and issue, so don't wait.
Beyond these big ones, there are just tons of other little practical rights that pop up day to day. Let's do some quick hits.
Yeah, absolutely. Consumer stuff first. Did you know about the 3-day cooling off period? For many door-to-door sales over $25, you have 3 days to cancel.
Get out, really.
Yep. Also, free credit reports, you're entitled to one free report from each of the 3 main bureaus every year. Annualcreditreport.com is the official site.
Debt collectors.
Oh, they have strict rules. No calling before 8 a.m. or after 9 p.m. your time.
Yeah.
No calling you at work if you tell them not to. And if you send them a written request to stop contacting you, they generally have to stop.
Good to know.
And remember, implied warranties aren't just for housing. When you buy a product, there's usually an implied warranty that it's fit for its ordinary purpose, even if nothing's written down.
Okay, communication rights hitting close to home for everyone.
Right. The Do Not Call registry exists. Sign up. Companies need your written consent for most robocalls to your cell phone now.
And emails, texts.
Commercial emails must have a working unsubscribe link. And for commercial texts, just replying S.P has to be honored. It's about reclaiming some control.
What about travel stuff? Getting bumped from a flight.
Ah, yes. If you're involuntarily bumped, airlines owe you compensation. It can be up to $1,550 depending on the length of the delay they cause.
Towing. Rental cars.
Towing from private property, many states require they notify you or the police fairly quickly. And that expensive rental car damage waiver. Check your own auto insurance or even your credit card benefits first. You might already be covered. Saves money.
So putting this all together, what does this mean for you, listening, right now? It really boils down to one thing, doesn't it? Knowledge is your first line of defense.
Absolutely. Knowing these rights is like having, I don't know, a shield. Or a superpower, like you said earlier.
Yeah.
And connecting this to the bigger picture again, organizations like the American Human Rights Initiative Foundation, AHRI, they're dedicated to making sure all Americans know these rights and can actually use them.
How do they do that?
Through education, providing resources, community programs, policy work. They have a great resource center. They really believe an informed public is essential because knowledge protects you from being exploited.
So don't let these surprising facts stay secret. Tell people. Think about those common myths versus the reality we've discussed.
Right, like my boss can fire me for any reason.
Myth. Discussing wages is protected.
Or police can just take my phone if I film them.
Myth. Not without a warrant or arrest.
My lease says as is, so the landlord doesn't have to fix anything.
Myth. That implied warranty of habitability can't be waived.
Companies own my data and can do what they want.
Myth. You have growing rights to know, access, delete, and opt out.
Exactly. Your rights are your power. They're legal protections, not just suggestions.
Yeah.
And it raises that important question, doesn't it? How many times have you, or maybe someone you know, faced a problem where rights were violated simply because nobody knew those rights existed? Knowing your rights isn't just self-protection. It empowers your whole community. So we really encourage you. Know your rights, share this knowledge, and be ready to defend your rights when needed.
Remember, these rights only protect you if you know about them and are willing, to actually assert them. Don't let a lack of knowledge leave you vulnerable.
That's the key takeaway.
To learn more, find resources, and understand your rights better, please visit AmericanHumanRightsInitiativeFoundation.org.
And your support helps them continue this vital work. Donations go directly towards legal assistance, advocacy, and crucial education efforts. Every dollar helps.
That website, again, is AmericanHumanRightsInitiativeFoundation.org. You can also reach out to them via email at info@AmericanHumanRightsInitiativeFoundation.org. Know your rights,